comes before the court on plaintiff's motion for cost and fees. I've received the briefing, and I'll give each side 10 minutes, but I have read everything. Mr. Thomas, good morning.
Good morning, Your Honor. I won't spend too much time. I'll save whatever time I have left for a rebuttal. And it's pretty straightforward. The court has looked at the briefing, and the plaintiffs are asking for about $60,000 in attorney's fees, I think about $175 in costs for e-filing of judicial copies. In this case, Lewis County is arguing two things. They said attorney's fees should be $25,000 without any substantiation. And in the alternative, attorney's fees should be about $43,475. And they do substantiate that. This court shouldn't even look at the $25,000 number. There's no substantiation. The lodestar is the well-accepted practice in the state of Washington. Plaintiff documented his hours, or I documented my hours in a declaration to this court. And this court needs to look at what hours are reasonable. Even Lewis County agrees with that, and they provide case law saying that hours need to be looked at for what is duplicative or wasteful or unproductive. And so that's what this court needs to do. Lewis County looked at it. So this court today should look at between the $60,000 number and the $43,000 number and find out what is reasonable and come to its own conclusion. And with that, I'll just let Lewis County make its remarks and I'll respond to that.
All right, you'll have 9 minutes. Mr. Eisenberg, good morning.
Thank you. Good morning, Your Honor. So the first thing I'd like to address is one of the last things Mr. Thomas addressed about $25,000. He argues that we didn't substantiate that, but the point of the Fetzer case that I cited to Your Honor in the brief is that that is an adjustment to a lodestar amount. In other words, after you do a lodestar analysis, the Bowers court had a concurrence that was concerned that sometimes when you do the bean counting exercise of a lodestar analysis, you will end up with a result that's much, much higher than the result that the actual clients received in the case, and that is unusual in contingency cases. And so it proposed that a vital consideration, I think that's the Fetzer case's gloss on that concurrence, that a majority of the court thought a vital consideration should be, after you do a lodestar analysis, compare it to the actual dollar amount of the case for the client, and if it's disproportionate, you have discretion to lower it down. And so Lewis County did a lodestar analysis. The result of that analysis we'll discuss in a minute, but you do have discretion, and it's essentially entirely up to you within reason as to whether you think in this case it is disproportionate for Mr. Thomas to get about 4 times what his clients got in light of the course of the case. I argue to you that the concentration that the plaintiffs made on bad faith and deterrence in this matter was only partially successful, and so it would be reasonable for Your Honor to think that attorney's fees should be discounted in proportion to that lack of success to be about twice what they got. Now I'll set that aside because that's really secondary to the lodestar analysis that this court must engage in. So I think it's quite clear that Your Honor should at least discount the drive time. This court has already ruled on that several times, and Mr. Thomas did not make any attempt to show the special circumstances that would be required for that drive time, so I would request that deduction. In the reply brief, there is some argument about Lewis County is not really entitled to argue for other reduced time because it didn't supply you with its own hours, and I'd just like to point out to the court that I am a deputy prosecutor, a salaried employee for the government, and I don't keep hours, and that's the reason I don't have them for you. But more importantly, it is, under the analysis, it is plaintiff's burden to show that their attorney's fees is reasonable. It is not Lewis County's burden to show that their attorney's fees are unreasonable. And a suggestion that I must produce evidence to you is burden shifting. So I would ask you to not discount Lewis County's briefing simply because it didn't provide you with a timesheet. What I did try to do was to give you specific examples of why I believe that some of the material that plaintiffs have billed related to unsuccessful claims, and Bowers permits you to discount unproductive time and unsuccessful claims. I divided the case into essentially 3 phases. In the merits phase, the plaintiffs prevailed. I what can I say? They get those attorney's fees, except for I think I proposed a couple of very small deductions. But then both parties filed cross motions to reconsider, and plaintiffs filed a motion to sanction us. Neither of those motions to reconsider was successful. In the reply brief, plaintiffs have argued that reconsideration was really about whether each plaintiff submitted the requests, and therefore he says he ultimately prevailed on that point. I don't believe that's really what that was about. If Your Honor looks back at that briefing, you'll find what they wanted was for Judge Schaller at the merits hearing to say plaintiffs submitted all three requests and they prevailed, all three of them, and we want you to decide it now as a prerequisite to any penalties analysis. And Judge Schaller rejected that in denying the motion. She adhered exactly to her prior merits treatment of the issue, which was to say that that issue is deferred until penalties, until Your Honor can decide. So that motion really was an unsuccessful motion. It was not work that was productive in their prevailing on the case, and so Your Honor should discount it as I've set forth in the brief. The motion for sanctions is an even easier one. That was very similar in many ways to the bad faith claims that Your Honor did not find successful in the penalties litigation. I think you should certainly discount the motion for sanctions, which was denied as unproductive time. In the penalties phase, plaintiffs concentrated heavily on some contentions that Your Honor did not rule in their favor on, notably extreme bad faith, the need for extreme deterrence, a per-page penalty, and a per-plaintiff penalty. It's very similar to the unpublished Green decision involving Mr. Green and Lewis County, which is persuasive authority to Your Honor. In that case, fighting about penalties in bad faith, when unsuccessful for the plaintiffs, did result in a reduced attorney's fee for them, and the court upheld that as being appropriate on appeal. It's very similar to this matter, so I ask Your Honor to similarly discount their plaintiffs' attorney's fees. I point out that they received about 1% of what they requested in penalties, and so I think that a 25% award of their penalties in that matter is reasonable. That's what I've argued mathematically for you in the brief. Finally, I have just a handful of miscellaneous things. Specifically, there were some declarations in the midst of the merits hearing about how plaintiffs had posted the transcripts once they got them on the internet, and therefore they must be public records. That was really wholly unrelated to the issues in the case, so I'd ask you not to award that. And then there was some fighting about the merits order itself. Judge Schaller instructed Mr. Thomas to prepare a merits order. He included in it things that she had not ruled on, which I objected to, one of which being that it was not the case that the court ruled that each of the three plaintiffs prevailed and was involved in each request. And based on my objections, Judge Schaller did not include those things in the final merits order. So I've asked for some discount of his merits order time based on the fact that that was not wholly productive. The final thing I'd like to talk to Your Honor about is the work for the fees and costs itself. I do ask that Your Honor make an award that includes this fee litigation in your award today. Otherwise, we'll just have to come back to talk about time he spent on this motion. I believe that Your Honor should not award time for the declarations that Mr. Thomas's clients submitted, again, alleging bad faith on my part. One, it's because those are not well-founded. I submitted a declaration which is not super relevant, just in case Your Honor needs to see that information. But also, it's just not related to the issue before, Your Honor. It's just unproductive time. So based on those things, Lewis County thinks that a Lodestar analysis would appropriately reduce Mr. Thomas's fees to $43,475. Then if you do the comparison that the Fetzer Court allows, you could reduce it more to 25 if you wished, to reflect the fact that you would still take twice what his clients received. Thank you. Do you have any questions?
No.
Thank you.
Mr. Thomas.
Thank you, Your Honor. I'll be quick. I don't think there's a lot to say. I just want to start with Lewis County's argument that this court can discount the statutory penalty. Lewis County ignores plaintiff's arguments in this, and it's kind of like two ships passing in the night. Lewis County is just asserting its narrative without even talking about plaintiff's argument. And it's not like plaintiff didn't come out with any substantiation or legal authority to this. We studied quite a bit of case law and talked about the public policy of the Public Records Act to explain why this court cannot discount statutory penalty fees, even if this court, which we admit didn't agree with most of our arguments. The point of the Public Records Act and the point of penalty fees is actually stated in a published case, Court of Appeals case. It's the Tiberino, and I apologize if I'm mispronouncing that. And it says, quote, "The purpose of attorney's fees is to encourage broad disclosure and to deter agencies from improperly denying access to public records." That's what happened in this case. We went on the merits, plaintiffs went on the merits. We forced disclosure of all 3 records. There was only 3 records in dispute. Plaintiff won on 100% of the issues that the Tiberino court says goes into attorney's fees. Statutory penalty is a legal operation that arises only if there's a violation on the merits. And as was pointed out in the reply brief, under Lewis County's logic, if the statutory penalty can be divorced from the merits proceeding, then people can go in and go straight to the statutory penalty. That doesn't make any sense. They're not separate legal issues. The statutory penalty is tied to the merits, and only if somebody prevails on the merits can they go to the statutory penalty. That's the reason why they're not separate issues, because then people could just plead and go straight into the statutory penalty, and there wouldn't be any need for a merits hearing if they were separate issues. Lewis County doesn't respond to any of this. This is bad faith again. So this court must award attorney's fees consistently with the merits and with the statutory penalty, because they are not separate legal issues. They're not separable. They have to be ruled together. And in fact, the Supreme Court talks about this. The United States Supreme Court talks about this when it comes to attorney's fees in Hensley versus Becker from 1983. It says, "In these circumstances, fee awards should not be reduced simply because a plaintiff failed to prevail on every contention raised in a lawsuit. Litigants in good faith may raise arguments or may raise alternative legal grounds for a desired outcome, and the court's rejection or failure to reach certain grounds is not sufficient reason for reducing a fee. The result is what matters. Plaintiffs prevail on the merits. That's the result. That's what matters." That's what Tiberino was saying, is that the forced disclosure is what matters. That's what plaintiffs did. What Lewis County was doing is they're not taking responsibility for their violation of the Public Records Act, for their illegality of their actions. They broke the law. They broke the law 5 times last year. The Thurston County Superior Court found 5 different violations of the Public Records Act last year, and they're continuing to try to skirt the law and to accuse the system. This should not be tolerated by this court. Let me see what else I'd like to touch on. The motion for reconsideration, Lewis County talks about that too. And in the motion for reconsideration, plaintiffs argue that all 3 requesters made the request. The declarations were submitted as part of the motion for reconsideration, where the requesters actually stated to this court, we made the request in conjunction with each other. We worked with each other to make the request. And this court actually referred to it in its oral ruling from the bench at the statutory penalty, which is part of the reason why it ruled the way it did. Lewis County actually signed 3 separate judgments acknowledging that there are 3 separate people who had a remedy in this case. It's mind-boggling how Lewis County can come up here and say that the motion for reconsideration wasn't successful. Even though this court denied the motion for reconsideration, it ultimately prevailed on those arguments. Plaintiffs may have lost the fight, but they won the war on that argument. The long-term approach is what should be looked at for that. And then plaintiffs also agree that the court should rule today on attorney's fees. We have no intention of dragging this out. I submitted a declaration also that I spent $1,650, or what is it, 5.6 hours on this litigation. So we hope that the court rules today. And one last point, the cost. Lewis County cannot segregate out the cost. And in fact, they're proposing an absurd result for this court. The statute actually says all costs. All costs must be rewarded to a prevailing party. Plaintiffs prevailed on all 3 issues in front of this court, all 3 Public Records Act requests. And Lewis County is saying that they should only get 1/3 of their costs, $59 out of $175. That's an absurd result. There's actually case law from the published case law from the Division I Court of Appeals saying that this is actually stronger language than in Title 4.85. And so this court needs to award all costs. Lewis County doesn't explain how all costs don't mean all costs. All costs means all costs. It means all the costs that we can substantiate as a part of this litigation need to be awarded. The dates correspond with the judicial filings in this case, and it's $175. There was I think, 12 or 13 different judicial filings during the course of this case. All costs means all costs, and this court doesn't have any discretion in order to go less, unless this court somehow finds that these costs aren't related to litigation or there was some sort of error with what the costs are claimed. Thank you.
All right. Thank you, Mr. Thomas, Mr. Eisenberg. Thank you both. I'm going to take this under advisement and will issue a written ruling. Thank you.
Thank you.
All right, the next matter I would like to take is matter 4, minor settlement regarding Mount Ventura. Moving on matter number 4. Oh, there you are. Good morning, and you are?
Matt Rinda, here on behalf of Minor Mount